It is never drafted by the client himself. The legal notice will basically call upon the will basically outline the grievance which the client has, call upon compliance from the opposite party to redress that grievance, and will also warn the opposite party that if the grievance is not redressed within a period of say 15 days or whatever, the client will then the person sending the legal notice will be well within his rights to institute the suit to claim redressal from the court. These are the contents of the legal notice, and you will have to give the facts, always the facts of the cause of action, why the legal notice is sent, the facts which you need the opposite party to redress will be recited.
This is an interesting question, because we have heard that the lawyers in US would tell their clients that you should not threaten anyone with legal notice until unless you are sure of taking legal action. There it is illegal to even threaten somebody of legal notice. If you are threatening somebody, then you should follow it up.
No, there is no such law in India. You can send a legal notice, later you need not institute a suit, because most of the legal notices will be replied with by another legal notice, and sometimes it does not get replied with another legal notice. Sometimes the parties compromise right at that stage. There is no convention in India that the legal notice should always be followed by a suit. No.
Earlier we were talking about transfer charges or other issues related to society and the tenant staying in that society. Now, when it comes to transfer charges, especially when you are selling a flat and there is a transfer of that flat, there are transfer charges put by the society.
Yes.
Now, often it happens that society itself decides how much the transfer charge should be, and the buyer or the seller is at the receiving end, because they can never have any say on the. Just a moment, we just got another caller. Hello.
Hello.
Yes.
Yeah, I wanted to ask a question.
Yes.
Can I ask?
Carry on. We can hear you loud and clear.
Should I ask you only?
Carry on, carry on. Both of us are hearing you.
Yeah. See.
Give me a name and place where you are calling from.
My name is Pranesh. My name is Pranesh.
Yes.
My grandfather had a property.
Mm-hmm.
He has four children.
Hello.
Hello.
Can you just reduce the volume on the TV, please? On your TV?
See, my grandfather had a property.
All right, carry on.
He has 4 children. But before selling the property, he didn't take the children's consent.
Yeah.
Carry on.
Yeah. So, do the children have any say in the property which he has sold?
No. When did your grandfather, was it a self-acquired property of your grandfather, or did he inherit it from his father?
He self-acquired it.
Okay. When did he sell it?
He sold it around 2000.
No, when the self-acquired property of a person is sold without the consent of the children, there is no problem, because right by birth of the children accrues only when the property is ancestral. It does not, the inheritance for self-acquired properties opens only on the death of the person who has purchased the property. It does not accrue during his lifetime. So, the children have no say in this sale, and it was unless there is only one exception to this rule, unless your grandfather, despite having bought the property as a self-acquired property, treated it as a joint family property and threw it into the HUF property, and the sons were co-parceners. This can be done based on it can be found out only through the facts and circumstances of the case. And if the children of your grandfather are pleading that it has been a co-parcenary property or a joint family property, only then their signatures ought to have been taken in the sale deed.
I guess the caller we have lost the caller, he is not online anymore. But there are so many other issues here. What happens if, is it true that this can happen only if the will is ready, or if the the grandfather had written a will when it came
See, a will will always take a property out of the purview of even a HUF. Let us say you have inherited a property from your, I am talking only about Hindus, let us say you have inherited a property from your father along with your brother, and therefore, you have a right to half the share of that property, and that half share is also your children also have a right in that property, but you can always that property you will have a right. If you have one son, he will have a right. If you have one daughter, nowadays she also has a right. So, that half share will be divided into 1/3 each, and 1/3 which belongs to the father can be willed away. So, that goes out of the purview of the co-personality property at all times. And if it is a self-acquired property, anyway your children do not have any right on it till you die without a will, and during your lifetime if you leave a will, that will take precedence over everything else. You can gift it to any one child to the exclusion of the other. The only thing is the maintenance of unmarried daughters and wife will always
take precedence?
No, will always be attached to that property. So, if there is no grievance about maintenance, that property can be sold at any point of time.
So, it's
and
not
you can also will it away to anybody you want.
So, it is not that as long as a person's wife passes away, it cannot be sold. It is not so.
No, no. The purchaser who purchases such a property will have to have notice of from the wife or anybody dependent upon that property that their rights have not been met. Only if the purchaser gets notice that maintenance is due from this property, only then the sale will be invalid. Otherwise, if he has paid good consideration and if the property is sold to him, the maintenance rights get defeated.
In case of married daughters?
No, the rights of maintenance of married daughters is always on the married daughter's husband, and if she is a widow, on her father.
What happens if it's not a Hindu family?
There is no right of maintenance for non-Hindus as such on the property.
So, no. They have a separate law for these things?
Yes. The Indian Succession Act will rule for anybody who is not a Hindu in terms of inheritance.
Is that a common law, or is it based on their religious texts?
The Indian Succession Act will apply to Parsis, Christians, people like that. For Hindus, you have the Hindu Succession Act, and for Muslims, you have the Mohammedan law, which is not codified. So, every other community will be governed by the Indian Succession Act.
Okay, Ms. Dhananjay, we were discussing about transfer charges. We broke off twice before. Now, in case of sale of flats, possibly the buyer and the seller is the receiving end, is at the receiving end, as I said. How does the buyer or the seller deal with that situation? If the society decides an exorbitant rate of transfer, what can it do?
The society can put it in its bylaws, and that bylaws at any point of time can be changed or amended. The majority of the people do not have to live with some rule which was drafted about by the core group when at whatever they please. It's always subject to amendments. It's always anybody who's dissatisfied can call for an AGM, a special AGM, a special general body meeting, and just have sufficient quorum and change anything they want.
Ms. Dhananjay, there are so many other questions related to that which crops up in your mind, but we'll have to close the show right now because we have completely run out of time. But before I wind up, I should tell our viewers that basically we wanted to convey our good wishes for our festivities, the ongoing festivities of Diwali, to all our viewers from the entire team from Real Estate Television, which include our reporters, our sub-editors, our online editors, the production unit, the cameramen who are all there behind the cameras making things happen in Real Estate Television. We all want to wish you a fantastic Diwali and also a very prosperous New Year after that. I'm sure in these days of hard times, our wishes would go a long way. We all need a lot of good wishes these days. Thank you so much for watching and have a good time.